31.
Your Honor, I believe he still has it.
I think he still does too. Does that say 31 on it, Mr. Dean?
Again, could you do me the favor of rereading the message of 11:53:27 again for me, please?
Yes. Would you like just the text of the message, or you timestamp, or?
Well, we've already established 11:53 on September 9th, I think. I think that's
right.
Clear. So if you would just read the content of the message, I would appreciate it, sir.
Well, I've had an interesting morning. I felt I should burn all of the limb debris by the fire pit before it got too soaked by the coming storms. While I did so, I spotted a big raccoon along the fence. I hurried and got my gun, and he was still walking along. I got close enough that one shot did the trick. He is now in our pet cemetery. Fun times.
So your purpose today is to obtain any messages on Tammy Daybell's phone, correct? And provide us with information about messages that were on Tammy Daybell's phone, correct?
Yes.
Okay. Your purpose today is not to decide whether or not wood was burned in a fire pit, correct?
No.
You don't have any information as to
Judge, I'd object. This is argumentative.
It's not argumentative, Judge. I'm trying to lay down exactly what the scope of what he's trying to do today. I mean, I think I ought to be able to inquire that he's here
Judge,
just to recite what a text message is and how he obtained it. I want to clarify that he's not suggesting to anyone that Chad Daybell did not burn firewood in a fire pit. And I think I need to be able to go into that.
I think it's pretty clear from the testimony and the foundation that's been laid by this witness that he works at an FBI lab and then he analyzed the phone. I think it's also clear that he's not trying to testify as to what those messages are. He's just saying what was found on the phone. So I agree it's unnecessary, and I think it is argumentative.
Okay, I have nothing further, Judge. Thank you.
All right, redirect Mr. Rammel.
Nothing based on that, Your Honor.
Thank you, Mr. Dean, for appearing today. If you'll hand that exhibit to the bailiff here, and then if you'll hand that report back to Mr. Rammel. The court notes that report was not marked and it's not part of the evidence. You can be excused. Mr. Dean, thank you for being here today. Mr. Rammel or Wood, do you have any other witnesses?
No, Your Honor.
The state rests then. Mr. Pryor, do you desire to call any witnesses?
There'll be no presentation today, Your Honor. Thank you.
Do the parties wish to make closing arguments?
Yes, Your Honor.
Mr. Wood or Mr. Rammel will allow you to do so.
Thank you.
If you'll please stand, make sure you pull that microphone close to you.
Thank you, Your Honor. I'm aware this court is very well aware of what the burden of proof is for a preliminary hearing due to the wide audience it reaches. I'd just point out that Idaho criminal rule states that if the court finds that an offense has been committed and that there is probable or sufficient cause to believe the defendant committed the offense, the court must find that defendant over to answer in district court. And so, Your Honor, just a brief recap. On November 25th, the Rexburg Police Department was notified of a missing child, JJ Vallow. The next day, their investigation begins. What they discover in the course of that investigation is that there's another missing child, Tylee Ryan, and they discovered that the last day she's seen is September 8th in Yellowstone National Park. They find evidence that on September 9th, Chad Daybell sent a text to his then wife, Tammy Daybell, at 11:53 in the morning about burning limb debris and burying a raccoon in his pet cemetery. That very same morning, Alex Cox's phone pings in that same area, that pet cemetery area on Chad Daybell's property. On June 9th, Tylee Ryan, who we've identified through DNA, is found buried, burnt, dismembered, portions of her in a green melted bucket, buried with animals in the pet cemetery. Through that investigation, they find that the last known sighting of JJ Vallow was September 22nd. The last known sighting of JJ Vallow was September 22nd. Similarly, on September 23rd, Alex Cox's phone pings on Chad Daybell's property. Near those pings where those pings are located on the north side of Chad Daybell's property, on June 9th, JJ is found. wrapped in a garbage bag with another white garbage bag wrapped around his head, bound in duct tape. Your Honor, for the court to find probable cause of concealment of a felony, it must find that the evidence concealed would tend to be evidence in a felony proceeding. That's the test given by state law, by case law in State v. Patia and State versus Yuramola. This court, as the finder of fact, is entitled to a reasonable inference based on the state of the bodies of J.J. Vallow and Tyree Ryan, that they were victims of a homicide. This court can also take note of through the evidence presented that both Chad Daybell and his wife, Lori Daybell, were aware that Lori Vallow Daybell was charged with desertion, 2 felony counts of desertion of a minor child in Madison County. And clearly, the location and welfare of these bodies was evidence in that felony proceeding. Those bodies were concealed. One of them was destroyed. They were located on Chad Daybell's property. Alex Cox, whose phone pinged near those locations, became his brother-in-law less than 2 months later when Chad married Lori Vallow. For the court to find probable cause of conspiracy on these charges, on counts 2 and 4, it must find probable cause of at least one overt act and an agreement. State law in Idaho is very clear through State versus Gallatin and through the Idaho criminal jury instructions that an agreement need not be formal or expressed, but may be inferred from the circumstances, or it may be implied by the conduct of the parties. Both Chad Daybell and Lori Vallow attempted to convince Melanie Gibb to either not cooperate with police or to provide false information to the police. At this point, they were married. In terms of finding probable cause that an overt act was committed, this court watched itself a video of Lori, at this time now, Lori Daybell, telling police officers that J.J. Vallow was in Arizona with Melanie Gibb. And then through a phone call where Lori Vallow Daybell and Chad Daybell were present, you heard Lori admit to that when she said she did what she felt the Lord was instructing her to do. Your Honor, for purposes of probable cause, the state has met its burden on all 4 felony counts, both counts of concealment and both counts of conspiracy to conceal. And we'd ask this court bind Mr. Daybell over to answer in district court.
Thank you, Mr. Wood. Mr. Pryor.
Thank you, Judge. Judge, in this particular case, we have 4 counts and we have 2 identifiable children. The testimony, according to this prosecuting attorney, is that Mr. Daybell was married to Miss Vallow. That's doesn't provide anything. Not only doesn't it provide an overt act, it doesn't provide an agreement. Marriage is not an overt act towards a conspiracy, and marriage is not an agreement to conceal or to conspire. In addition, what they have is Mr. Daybell making a comment to a police officer. That is not an overt act to conspire or an agreement to conspire as well. And then what they have is they have an obscure text message that says, I burned some items in the fire pit and I buried a raccoon. Now, they can suggest whatever they want with that, but there's been no indication of any evidence that this act took place on the 9th or the 22nd or 23rd or whatever day it was. And quite honestly, Judge, they don't even come close on the concealment of Tylee. They don't even come close on the concealment of JJ. And the conspiracy, they lack the agreement And quite honestly, Judge, if this is what the evidence is in terms of an overt act, I would submit to the court that I understand the burden in a preliminary hearing, but they aren't even close on the conspiracy in either suggestion that in either case in regards to an overt act plus an agreement. I'm respectfully asking the court to dismiss the charges. They haven't met their burden, and I don't believe they provided any near the type of evidence that is necessary to even overcome that small threshold. Thank you, Your Honor.
Thank you, Mr. Pryor. Court is going to take a recess.